Now that the dust has settled on the Supreme Court's birthright citizenship ruling, I want to answer the two questions I've been getting the most since the decision came out. Questions we didn't have time to fully cover in our initial breakdown. Welcome back to US Visa News Hub. I am Mr. Burhan. Quick recap. On June 30th, 2026, the Supreme Court ruled 6-3 to strike down the executive order that attempted to end birthright citizenship, reaffirming the long-standing rule from Wong Kim Ark. If you are born on US soil, you are a US citizen, regardless of your parents' immigration status, with only very narrow exceptions like children of diplomats. The court also directly addressed the subject to the jurisdiction language in the 14th Amendment, clarifying that for birthright citizenship purposes, it simply means being physically born in the United States. That closes the door on future arguments trying to redefine that phrase. This video is for informational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation. Now let's go deeper. The first question people keep asking is, can Congress still end birthright citizenship after this ruling? The answer is yes, but only through a formal constitutional amendment, not through legislation or another executive order. Since the Supreme Court's ruling reaffirms that birthright citizenship is rooted directly in the text of the 14th Amendment, the only way to change it permanently would be to actually change the Constitution itself. That requires either two-thirds approval in both the House and Senate, followed by ratification from 3/4 of the states, or a constitutional convention called by two-thirds of state legislatures, which has never happened in US history. Given how difficult that threshold is, and how divided public opinion is on this issue, most legal observers do not see this as a realistic near-term path, even though it technically remains available. What this means practically is that birthright citizenship is about as legally secure as it can be right now, short of a generational shift in how Congress and the states approach the issue. The second question, and this one is more personal for a lot of families, came from people who were pregnant or expecting during the period when the executive order was in effect and being challenged. Many families, understandably anxious, began asking immigration attorneys whether they should apply for dependent visas like H-4 or E-2 for a child who hadn't been born yet, out of concern that citizenship might not automatically attach at birth if the order survived. The consistent advice from immigration attorneys throughout that period was to be cautious about making long-term legal decisions based on an executive order that was already being heavily challenged in court and was legally uncertain from the start. It's reasonable to think ahead and have a backup plan, but overreacting to a policy that hasn't been finally resolved by the courts can create its own complications. This case is a good example of why. The executive order was blocked almost immediately by lower courts and ultimately struck down entirely by the Supreme Court, meaning any family that filed for a dependent visa out of that specific fear did so for a policy that never survived legal review. The bigger lesson here applies beyond just this case. An executive order or policy memo isn't the same as settled law. It becomes lasting only if it survives the courts. And that's especially difficult when it conflicts with constitutional precedent that has stood for over a century, as birthright citizenship has since the 1898 Wong Kim Ark decision. So where does this leave families going forward? If your child is born in the United States, regardless of your immigration status, visa holder, green card holder, or undocumented, your child is a US citizen at birth, full stop, under the ruling that now stands. There is no need to pursue a separate dependent visa for a US-born child's citizenship status. That said, immigration law can shift, and if you have specific concerns tied to your individual situation, it's still worth a conversation with a qualified immigration attorney rather than making assumptions based on political headlines. If this deeper look answered questions you still had after the ruling, Drop a comment and let us know what else you'd like covered. Subscribe to US Visa News Hub so you don't miss the next update. Thank you for watching. This video is for informational and educational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation.